Okay, Jeff, will you get back with me on that?
Yeah.
We're live stream. Here we go.
15 minutes away. I definitely will.
There's a guy now, chicken tree farm, Christmas trees. If you're ever out that way, you want to drive to see the barn, you cut every sticker wood. It's all came from West Tennessee. Absolutely gorgeous barn.
I think that's for Zoom trials.
Zoom trials, okay.
They haven't seemed like they have a lot of them.
Listen, it's always sitting somewhere else. That's
That's
great.
really good for the house.
Would you like to sit by me? I don't mind sitting by you. Okay. You don't mind sitting by me? That's all the call to do school.
Me three.
And I have a math.
I did.
We like to try some like covered.
That's not what I think about it. Because I will do. No.
Absolutely. You're under maybe make it more.
I never really asked her about the same part. They got the volume, so it's not like she can't. But
Doing all right. How are you?
She could always go back.
well, that's so. Certain shows they've done something where they basically they take all their recorded hearings. And if somebody wants a transcript, they go back. They listen to the hearing. You say, take it as Kevin. I did. I trained.
Yeah, I'm sorry.
You say something I wouldn't
He's
fit.
probably not going to be able to slate. He said EPA was 113. I really just driving like 28, hit the freeze.
Unless you got it for Google, it's like, you'll be there.
Well, knowing him probably does.
She never really said how the Zoom hearings could be a bit. But usually where she was who sits there?
Never actually been to one. I don't really know. I think Drew did it a couple times.
If you go upstairs, you'll see like a bench. Actually, Brad said it would be this. The bench is standing wherever the recorder sits. I'm not sure if you were put on the stand here, where you'd actually sit. That would be the Brad seat, and the recorder would sit down here.
Probably should stand here, stand here, be like this.
It's kind of odd, odd laid out bench. It's not like Law and Order where you've got a judge and that person sitting. Well, that's, you got one.
It's always not the same, is it? When you meet outside. Yeah.
I know.
I went to Reading in there the other day, just out of curiosity, looked up there, dang it, it works. One on the old.
Just trying to figure out where to go.
Doesn't have to take together.
First on the agenda is public body comment. Public body comment. Public body comment.
Mr. Chairman. Oh, go ahead. Go
I
ahead.
got one. I'm sorry, what's your name?
My name's Sandra Graven, and I think you guys need to decide what you're gonna do, because farming will soon take precedence. I mean, farmers are looking now at the ground and stuff that they're getting ready to farm. And have you guys ever thought about a farm manager, like through a bank, or, I mean, that's just kind of a thought. And then there's always cash rent. So I didn't know whether all of that had been thought about.
We got some of that on here.
Okay, okay.
Chairman, will we be able to interact as we have been in the past?
Well, somewhat, but
Okay. as long as we keep it-
I would just assume you get it all out.
Well, I
You're
don't,
supposed to.
I guess depending on what direction the meeting goes, I did some research on that 1049.2 and wanted to see where you guys were going, to see if there would be comment at that point, if that would be allowed.
What's the rest of the committee say on that?
I think it was some pretty valuable information. And keeping it open,
Okay.
keeping it open.
Thank you.
Any more? Kurt?
If, again, I'm not sure what you might like to act on the agenda, is the goal with the two items on the agenda that you're thinking now to lease it this year with the intention of next year doing custom farming? Is that the long-term plan?
I don't think that was, it was either or.
Okay.
I mean, we wanted to discuss both options, is
Okay.
more of what's put on there.
Well, I would like to emphasize, and this is, I wish I would print copies for everybody to read it. But in the 1049.2, the county board may lease real estate acquired or held by the county for any term not exceeding 99 years, and may lease the real estate when, in the opinion of the county board, there's 5 prongs. The real estate is no longer necessary, appropriate, required for the use of, profitable to, or for the best interest of the county. With statutory construction, the way that reads, you have to break those items out. The real estate is no longer necessary. You have to answer that question, yes or no. The real estate is no longer appropriate. You have to answer that, yes or no. The real estate is no longer required for the use of the county. Yes or no. The real estate is no longer profitable to the county. Yes or no. The real estate is no longer for the best interest of the county. Yes or no. All 5 of those prongs are together because it doesn't say or. It's comma after each one of those prongs. That's basic statutory construction. I urge you to answer those questions before you decide to take this to the board, because the last meeting, the one thing I said, and I do appreciate, and I know you haven't always got the outcome you want, you guys are reading the statutes and you're following the laws. That's all we've ever asked as an organization. The budget issue, I know it was a roadblock, but you followed the law. I would hope that you don't try to go down this path, because those questions, specifically the no longer profitable, it's been well established that it's profitable. So I don't know how you get around that. That's all I have. Thank you.
I've got several questions. Your 1049.2 statute is a state law, and it's required to fit within the confines of the Constitution. Any laws that are repugnant to the Constitution are null and void. Article 8, Section 1 in the state constitution says, public funds, property, and credit shall be used only for public purpose. Only is a very important word in that sentence. You are required to have public purpose for the use of public property, and you're also limited to public purpose. And I would pose the question, when a private person takes home personal profit from public property, where is the public purpose in that? So, when the farmer sells the grain, makes money, that's using public property for private gain, not public purpose. That's been the problem with this for 2 years. So the word only there is very restrictive. I want to ask some questions. This maneuver, I think, was tried about 4 times last year, and I'm wondering what has changed. Can anybody tell me what's changed this time?
You want to speak up, Brian?
I presented the statute to be amended to the IACC committee a couple weeks ago. At that time, the committee found no reason why we were not legally able to farm using this statute. Numerous counties, they said, were doing that at this time. And one of them was there, actually had legislative representation on that committee, and said they were doing it with this statute. I feel this is a viable option still. They looked at me when I presented this like I was dumbfounded that we weren't able to use this statute to lease this farm. And I guess with the handcuffs that have been put on us in the last week, we're just looking for an option that we are told we can legally do, not only by the people in the IACC, but by our state's attorney here in our own county, and trying to find a way to get this taken care of is where I'm at.
Who's the IACC?
Illinois Association of County Council, which is also IACBM.
John?
What was the other county that was there?
I can't remember what one it was off the top of my head. It started with an L. Because he said they use that statute to rent their farm ground.
Livingston?
Might have been. It started with an L, that's all I can remember.
Could you tell us whether they identified what the public purpose was for the use of the ground?
Did not get into that conversation.
And that's the part that gets missed in most of those conversations. I'm sorry, go ahead.
Yeah, I mean, it would have been helpful if public purpose had been discussed, because if you meet that, then you're golden. You're good to go. But when a private person takes home personal profit from public property, can you identify the public purpose in that?
Go ahead.
If I'm a farmer farming that land,
No, it's okay.
they're required, they should get some money out of farming it for the public, or for the purpose of the county.
And I'm not saying a farmer shouldn't be paid for his work. You put your blood, sweat, toil, and tears into it.
Exactly.
But we have the matter of law to deal with, and we have to have public purpose, and only public purpose, according to the Constitution. In fact, the annotated version of the state constitution goes so far as to say that the use to which the lessee puts the land must benefit the public. So how is that benefiting the people of the county when he's taken home personal profit from public property?
But the county's also getting money.
That's true. But the word only here is what kind of hamstrings you. You have to have public purpose, but you also can't have anything but public purpose.
All right.
You can't have 51% public purpose and say, okay, we got public purpose. It's got to be 100% public purpose. There can't be anything else.
I can give you an example, Chairman, if you'd like an example for that statute.
Just a second, got one here ahead of you.
You know, we're talking and dealing with all this crap. Let's go back to the Illinois Constitution. Where at in the Constitution does it say that?
Article 8, Section 1,
And what is Article 8 talking about?
finances,
Finances.
and property, and credit.
No, it's not. It's
Yes,
talking
it is.
about
Public
finances.
funds, property, and credit.
No,
All
the
three
very
versions-
heading at the very beginning of this thing talks about finances.
If you read the Attorney General opinions, all, and case law, all three apply.
I'd love to see
Public
it.
funds,
I'd love to
property-
read them.
Okay. Public
I wanna
funds, property,
interject.
and credit. Yes, sir.
I would like for one to finish speaking before the other does.
Well, in that case,
I'm sorry, what'd you say, Mark? I didn't want to get to be a back and forth, just one person speak. What? Kirk had his hand up, so go ahead before him.
The original, when that statute was enacted, that you're looking at, the county that pursued that did lease their building to a private entity. The private entity was providing a public purpose with what they were doing with it. It was a private nonprofit that provided a job service program in that building that benefited all the public. So when the Constitution talks about being able to identify a public purpose, it's just not the county receiving money, it's what is the use of the land? Does it equally benefit the public in that use? And that's where the Attorney General opinions and the case law point to the use of land, and that's the stumbling block across the board. And everyone we've talked to that says, well, we can do it, they never want to talk about the use of the land and how it ties to public purpose. But that's how that statute was created. The second prong, when we look at other counties as doing it as the justification, many of those counties are doing it with the confines of a statutory provision, one including a senior home, very similar to the poor farm that's outlined in the statute. Others are airports. That wasn't disclosed to a lot of people, and everybody justified it's going to be, hey, 30 or 40 counties are doing it. Many of them are doing it legally. Unfortunately, you folks don't have any of those prongs that open that door. Thank you.
yeah, Article 8, Section 1A starts with public funds, property, and credit. So funds, property, and credit are covered in there.
I like that ringtone.
Sorry about that.
Hey, Jesse.
Yeah.
I had a quick question for Brian. On that committee, you had, you was talking about, did they give you like a written document stating that particular legal avenue?
No, it got tabled. We are currently looking for, to be honest with you, a sponsor to take this to the House or the Senate to move it forward, what we were trying to do.
Thank you.
We'll see if Bradley's spot, I'm just joking, never mind.
I got two
Oh,
more.
one more.
I got at least two more questions. The agenda changed twice on Friday. There's version 2.0 and then version 3.0. What was going on there with the last minute changes to the agenda?
Clarification.
Well, mostly because of what happened at the main meeting there. There's no budget, so we put this back on there.
So after the board meeting on Thursday night, several members of this committee put an agenda together for this meeting. Was that a meeting?
No, we didn't have no meeting.
Were you discussing business?
No business.
So, gentlemen, if I could jump in, Jeremy, so 4 of the 5 committees here today met upon adjournment of the full board meeting the other night, Thursday night. So share with us what the discussion was about, because it looks like there was no meeting posted for the farm committee at that upon adjournment. So what was the discussion like?
I was approached by one person, asked if they wanted anything, if I wanted anything on a new agenda. Do not speak with the others. About what was on that agenda. Until I seen it come out in the posting, I had no idea.
Well, it just, there was 4 of the 5 members of the committee was up at the front table, at the chairman's table, and the state's attorney was looking on. And
So it just seemed strange in the light that I think the agenda item 13 was not picked up or acted upon, what the discussion was.
I do not know that we all were speaking together. They may have been speaking to someone else, but I was only spoken to by Brian. If there's something I wanted on the agenda.
Okay.
And I did not see anything else that was written, other than comment I made.
And to Jeremy's point, I mean, these agenda items from Thursday to Friday morning and late Friday morning, I mean, these agenda items change dramatically. You went from custom farming agreement, custom farm bid packet, FSA and NRSC, to licensing agreement, Kankakee County, a vote on input sourcing of payment, to the third agenda was item 3, a discussion vote on the recommendation of the county board under county section 5-1049.2 county's code, and then the discussion vote on the custom farm arrangement. So there was a dramatic change from Thursday until late Friday morning. So I guess it's clarification if you want to call it that, but it just looks like a dramatic change in, I don't know, 24 hours as far as these agenda items.
I was in touch with Jesse Friday morning before that come out. I mean, as far as changing the agenda. That was Friday morning, wasn't it?
Yes.
Yeah, I mean, I think from the agenda that came out Friday morning, there was about a 2-hour time difference in the emails notifying the public about the different agendas, which was well beyond your 48-hour time limit for OMA. But that's not the issue. It's just that there was 3 different agendas in less than 24 hours, and the agenda items changed dramatically. So, I mean, at some point, you get to 48 hours or the close of business on Friday, the agenda has to stop changing. And I'm just kind of curious why the dramatic changes in the item. I want to see it more than a clarification.
Any more public body? Did you have something else?
Mr. Chairman, I have one more thing I'd like to talk about. Mr. Kaufman, I'd like to ask you a couple of questions. Are you an engineer? It's a simple yes or no question. I think the answer is probably going to be no, because on the IDFPR registration of professionals, your name doesn't appear as a licensed engineer. But I have First Amendment, freedom of speech. So, did the Road and Bridge Committee ever send a recommendation to the full board to make you the county engineer? Did the full board ever approve any kind of recommendation like that? I mean, they did on December 20th for another gentleman, but...
I'm sorry, what does this have to do with
I'm just going to say
farm
what.
committee?
Well, it's...
This is farm committee.
It is, but one of the things that's been mentioned as far as public purpose of putting the funds toward were maintenance of roads and bridges, etc. And so it kind of ties the two together a little bit. So I'm looking at, I've looked at minutes from the Road and Bridge Committee and show no such recommendation. I look at minutes from the full board meetings and see no such action taken. And also the Prohibited Officers Activities Act states that a county board member cannot be the highway engineer at the same time. So, Mr. Kaufman, can you answer, have you been acting in any capacity as the county engineer?
I
be a fairly simple yes or no question.
I don't believe this has anything to do with this committee here. At another time, maybe you can.
I've got a document here that says the answer is yes.
It says what?
Says, it seems to indicate that the answer to my question would be yes, because this is an invoice to Shelbyville Township for salt, signed by Brian Kaufman, acting county engineer, and I just wondered where that came from. How can you act as the county engineer when you're not an engineer, you're prohibited from being there, and nobody's ever legally put you in that position?
Well, doesn't somebody have to make those decisions whenever they don't have a county engineer?
Well, there's a process for that, but we can't do it illegally. We still have to follow the steps of law.
So you're saying put all that off, no salt for anybody until they get a county engineer?
No. Okay. No, I'm just saying what we do, we have to do legally.
I'm sorry. I think that's something for another meeting. This is farm committee.
Actually, I was gonna just chime in, Chairman, and I'll be all done. I think this becomes an ethical question, because now you've got identification of a board member sitting on this board that has used the title engineer, and if he's not an engineer, there's some serious ramifications in the Engineers Act. We've dealt with this with architects before. It's use of the title, why it's an ethical question, he's on this board, so ethics becomes a question.
Yeah.
You also are on that Road and Bridge Committee, if I recall correctly. So how did this happen, and is this the type of behavior we're going to follow in this committee? I haven't seen that, and I said that at the last meeting, but this is concerning.
I would like to know how many documents like this have been signed. I mean, that's just to one township. We got a couple dozen townships and municipalities, and the statute actually says that falsely passing yourself off as an engineer could result in a fine of as much as $10,000 per occurrence. So if we have more than one occurrence here, we have an even bigger issue. It just blossoms and explodes.
We did have some comments go back over here.
I didn't see it.
Okay, I had my hand up, Jesse. I guess to bring this back around to the circle, is our main goal this year is to see that the county farm gets farmed. I don't see that it's gonna be possible for it to sell, you know, in the time period, the restraint we're under. As I was looking through that 1049 to, if it was deemed that it could be leased for this particular year in order for the board to get their line items, you know, set in place to be able to allocate funds where they needed to be, or make a determination of the purpose of the ground going forward so that it does not sit idle, because I did hear someone say, I don't even know that we have the funds to even put it in a cover crop. So I guess one of the things that I've dug into a little bit, if we look on farther down at section 10, and you'll have to excuse me, I was in a hurry and I forgot my glasses, but 5-1051 says charitable donations for aid to persons in need of assistance the county board may accept or receive through unsolicited gift, grant, charitable donations. Okay, so my proposal is if this ground is deemed that it can be leased, and I already have an estimate expenses drawn up based off the comments I heard you guys talking about, that if an individual, myself, whatever, farmed this property, there was $59,000 approximately in custom farming, whatever you want to say, call it, inputs, seeds, all that was taken on by the leasee. And then at the end of the year, when the crop is sold by the farmer, not the county, so there's not a patronage issue, then there was a donation made back to the county based on a 60 bushel average at $12. You could sell fall beans right now for $12.58. That possible donation back would be $70,141. Could that be put into that section 1051 and used for Shelby County Community Services, the food bank, for this particular season to get us over a hurdle? That's my main question that I had, why I was asking if we could comment later in the conversation. If that would help us as a county benefit from that farm this season, get our budget in line, and figure out what we're going to do properly as we move forward. Thank you.
What statute was that again?
Which, the second one that I
Yeah.
referred to, it was statute, and I was digging and man, I'm sorry about that. Yeah, it was 1051. Yeah, 1051 with nothing behind it. Charitable contribution for the aid to persons in need. You know, and I thought of Shelby County Community Services. We are helping the underprivileged, the youth or the young adults that aren't able to provide for themselves. We've got an awesome facility out here that a lot of counties don't have. Could we assist that group this next year with funds from the farm or to food pantries, you know, or something, just so we can get through this season and get over the hurdle that we're not able to climb right now. You know, and then that would address, Jeremy, what you're talking about is a person wouldn't necessarily gain personally from that. You know, it would be donated back to the county. You know, with however the Lord provides us with rain, I can't give you a dollar amount because I don't know what's going to happen. But I would insure it at 80%. That would be a revenue of about $103,000. If we had about $60,000 of input costs and custom farming expenses, seed and crop passes, the county could still be looking at possibly, you know, a $20,000 to $30,000.
Can I ask you a question?
Yeah.
So would the farmer be paid for custom farming?
Yes.
So he's getting a personal gain, right?
For the passes across the field.
Right. But that comes back to personal gain, right? On
Service.
Well, it's service. Is that, unless I misunderstand it, somebody's got to help me.
Okay, yeah, I don't know. I was just.
Providing a service is different than selling a crop and pocketing excess above what they would normally pay the, you know.
So I guess, or could it be deemed, my original comment was, before I even seen 1051, was presenting the board, can we be a steward of the county farm and make a donation back? Is that better, you know, than using leasee? Can the county board approve someone to be a steward of the county farm this year, or a caretaker? And then, with the agreements, you know, I mean, I'm personally saying we would give back the overage back to the county. So there would be no massive personal gain in this, just asking that our expenses be met and the county farms it and we get our ducks in a row going into next season, because I heard that being we cannot amend the budget at this particular time. It's too late, but we can come August. So I guess that's what I'm asking. I don't know, I'm just throwing it out, there's an option.
Any more comment?
Jay, you got any comment on that?
I was gonna ask Jay if he
You
could
can
do any
lease it.
comments.
That's the bottom line.
What is it?
What'd you say? Sorry.
It can be leased.
What? The farm?
The farm.
Okay.
Under what statute? I'm sorry.
This public purpose stuff is a little out of context. The public purpose is making money for the county.
Supreme Court said otherwise, and we presented the case law on it.
Well, I've reached that conclusion, Nicole's reached that conclusion, Giffen Winnie reached that conclusion, the Attorney General reached that conclusion.
AG didn't reach that conclusion.
Yes, it did.
No, they didn't.
Do you have that
Not gonna
supporting
argue with you.
documentation?
The
Pardon?
AG was.
Do you have that supporting documentation with you?
That's all been
Of
presented.
these opinions? I mean, you're talking about this,
I've given the opinion.
what about a written opinion? And the supporting
I believe
documentation?
Nicole gave a written opinion. I believe Ms. Cronky gave a written opinion before.
Kind of vague there, you believe. I mean, I'd like to see a written opinion with supporting documentation that states that. Because you're denying what he says, and you're saying otherwise, so prove it. Simple. That's all.
Are you referring to the opinion that the Attorney General's office sent last year?
Yes.
The one that wasn't signed by the Attorney General?
So vague.
It wasn't signed by the Attorney General, and
You
it
mean by
said,
Kwame Raoul?
correct.
No.
And they weren't asked the proper question.
And they acknowledged there wasn't enough information to provide a complete opinion on the subject.
And in the final
Part
paragraph,
of the subject. They clearly said it could be leased.
and in
As
the,
did Giffen Winnie.
Yeah, it can be
As did the
leased.
state's attorney, as did I.
You're right, it can be leased. There's the qualifier why I mentioned it, Chairman. This statute is created, you can lease it. You can lease it, no question. It has to meet the public purpose. The building that was leased had a public purpose in that the nonprofit was providing a service to the community as a whole. This is a case where that question hasn't been answered. You can lease it, but you have to meet the public purpose criteria for the use of the land. That's in the annotated constitution. Receiving money is not the term public purpose. That's not the only prong to it. And that's spelled out very clearly in numerous case law.
that document from the Attorney General's office, in its final paragraph, even said, this is not an official opinion. And in about 4 or 5 places in that document, it said they weren't going to touch it.
Because there wasn't sufficient information in the question.
They said they were not going to deliver a definitive opinion on the matter. That's what the document said in multiple places. I'm sorry, but that document was absolutely useless. It was not an Attorney General's opinion. It said so, and it said in several places it wasn't going to answer the question.
Unbelievable. Here's the document, you want to read it. And like he said, it says numerous places, this is not a legal opinion. So no force effective law, and the judge will throw it right back in your face.
With respect, and I do mean that, on December 20th, you were asked a couple of questions about legal procedures for amending the budget. And you gave 2 responses. The first one was, it's above my pay grade.
As to ARPA, the county paid somebody for opinions on ARPA.
Bellwether.
I do not have the time to become an expert on ARPA. We had him waiting on the phone, or waiting, I've said several times. This is something you want to run by him. Nobody wanted to do that.
Well, as an assistant state's attorney and a former state's attorney, I would think amending the budget wouldn't be rocket surgery, as they say. And when you say it's above your pay grade, I have to ask if the board's legal counsel cannot deliver a question or an answer to that question.
On ARPA.
Okay.
So there was 2 questions. One was about ARPA, and that was a different response. The question was about amending the budget. That's when you said that's above my pay grade.
I mean, that's statutory.
There is videotape to that effect. There is videotape to that effect.
I'm not denying it.
Okay.
So if
So
it's
answer his question,
if-
Mr.
This,
if it's above your pay grade, whose pay grade does it fall under? I mean, you're part of the legal counsel for the board, and your second answer to that was go ask someone who's not a lawyer, because I don't think Bruce is a lawyer.
Let's move on. We have on the next, if there's no more that pertains to the farm, let's move on. We got old business on there, Mark, I do believe you.
I asked to put old business if there's any old new business on the agenda. I do not. Well, I take that back. A lot of what's already been stated here, I guess, does fall under the old business of, as was said by many people over the last 8 months, how many times are we going to drag this dead horse? I understand where people have read various his documents, but I still have to fall back that there's not been a document stated to us other than in 1974, Attorney General said he could not lease the county property for public use. I believe there's some other documents, maybe 1993. I'm sorry I'm late. I did not bring the folder with all the paperwork in it. I had an emergency to take care of, so I cannot back up everything I say. But I do have it. If anybody wants it, I would be more than happy to give a copy, as well as I think there's other people that have it. I was not aware of what all was on our agenda till I saw it the same as anybody else, so I cannot actually say what we're attempting to do today, except listen to what others have to present. But there's nothing to turn my opinion around right now.
Your opinion is what?
The way I voted last time.
Which was what?
It's on the record. Just proceed, please.
Anybody else want to discuss old business then? Which pretty well pertains to 3 and 4.
Old business discussion, okay. Well, when you look through the 1049-2.2, you got to take a trip down history road, memory lane, whatever you call it, and just as a reminder to everybody that the Poor Farm was instituted in 1867. It was abolished in 1967, both of which were done by the state legislature. So when you look at the requirement of piece of 1049, and I'll find it here in a second.
What's the date on it when you find it? When was 1049 done?
What does it matter?
Well, some of this stuff is in the 70s, some of this was in the 1800s.
The statute's still standing today, so therefore it stands today.
As do the ones that are older.
The public comment was over.
Yep, it is.
So 1049-2, as it was described in public comment, the real estate is no longer necessary, appropriate, required for the use of, profitable to, or for the best interest of the county. When you look at required for the use of, the Poor Farm was required for the use of the almshouse, instituted in 1867, because that's when the county was founded. It was 1867, roughly here or there, thereabouts. Well, in 1967, when the county almshouse Poor Farm went away, the required use of went away. That is one of the requirements to lease of county property. So, may be it that there are several other counties that release their land, whether they do it under the airport authority or the old folks home, whatever they call it. Maybe they have a legal venue. We don't have a legal venue to lease the property. And that's where it's the way it's been since 1967. It was challenged in 74. The AG stated their opinion. It just seems to me kind of interesting that there's a lot of opinions stated in 74 that took 7 years to get, basically once the legislator made a decision, made a change, it took them 7 years to get an actual opinion out. But it's here nor there. But
It's not been challenged.
and it hasn't been challenged either. But when it gets right back to the public purpose in the annotated Constitution, page 127 or 129, my memory's faded me. It's been about a year since we've had this last discussion, but somewhere around 127 or 129, it specifically states and talks about Article 8, Section 1 of the Constitution, whereas both the government and the private entity have to have public purpose. So the private entity in this situation would be the farmer, and the farmer does not carry public purpose. So I just leasing and renting is not an option, and quite frankly, what we were looking at before with custom farm was a slippery slope, but anyway, that's all I have to say about it. Yeah, Mark.
I believe we had a solution that would have worked, it's just our time frame was off, unfortunately. This is why, farm committee, we needed 5 on it previously, so we could talk and try to get some of this solved. This was also the reason I thought we had something worked out August, September, so that we could actually got it on the budget. If we had accomplished that in a timely manner, then we wouldn't be speaking here today, I don't believe. I think Thursday's meeting or previous to Thursday's county board meeting, if it would have happened last fall, we would have had our time frame correct. I regret it for everybody, but
Even the appropriations would have had to take place back in April, May of last year. That way it could have been put in front of the executive committee for review and proposal. So really, we're not that far out from this year's 2022-23 budget being proposed, so.
I mean, we all hate it, but we have rules we try to go by.
Jeff, you have any comment?
Yeah, I'm gonna kind of read a response from Nicole here on the 1049.2. I'll just kind of put this in a nutshell. If you go back to the transcripts of that debate, it occurred to determine the intent of the legislature was when the bill was introduced, voted on, and passed. The bill passed in 1993. The transcripts had never been prepared, so there was significant delay between the request for and receipt of the transcripts. And I don't have a copy of the transcript, so don't jump all over me. The first page of the attachment to the statute, 55 ILCS, 55 blah, blah, blah. I'll just get to the nuts and bolts here. The bill was introduced to assist Kankakee County in renting surplus property. During the floor debate, the questions were asked. You said the land being leased to the government and or to private individual. Is this going to be to a government agency or a private individual? The response from one of the bill sponsors was, my understanding is the language is drafted so they can lease to either a government agency or to private interest that may be interested into additional office space. They see this as an opportunity to gain some additional revenue. The transcript shows that the intent of the state legislature at that time the bill was passed was to permit a county to lease county-owned real estate to private interest in order to generate additional revenue for the county. The bill passed the state Senate by a unanimous vote, and the statute applies to all counties in the state of Illinois. I'm done.
Mark.
Okay, I would like to ask Jay, your interpretation of what you just heard. Intent, doesn't it have to be written in the statute? Because we can have a conversation. People, to me, intent, that what he just spoke was a conversation between two people of what they thought it meant. But did it actually say that in the statute?
The floor debate is how you determine what the intent of the statute is.
But what is written in it and how legal counsel reads that or what it actually says is what's law, correct?
Correct.
Wouldn't every attorney have an interpretation of every statute?
They could.
And so it would just be the words in that statute, right? So what Jeff said is the words that weren't in the statute itself.
but that was the intent behind the legislation.
I'm sorry, but that doesn't clarify anything to me. That's just another opinion.
It's my opinion.
Okay? But it's not written in the law, so it's not necessarily the law, is it?
But there's been 4 attorneys now have said you can do this based upon that and when the statute is written.
But we wrote to the Attorney General, and at the end of it, it says it's at the end of his document, I believe that Jeremy was talking about. The last.
It did say you could lease the property.
Did it also say this is not a legal opinion at the bottom of it?
Not a, what is a binding opinion or?
Official, it said it's not
Official,
official opinion.
But it's another attorney's advice. There's a difference between informal opinions and official opinions of the Attorney General.
I think the question mark really needs to be pointed at, what did Kankakee County do with it to get into their position of being able to lease their property? Who did they lease to? Did they have public purpose, or was it to I'm gonna throw out was it a Walmart or a big box store that came in and leased the property and had, that's not even a good analogy, because that's open to the public. But,
The only thing, I believe the only thing we saw, go ahead, Jeff.
Yeah, what he's got it,
I asked Kankakee County that question, and it was to a nonprofit, and I have the email and on my computer at home, and I can't remember the exact words they used, but it was not for private business.
It was a private nonprofit that served a public purpose in providing a community service.
so that would be like, if I'm pulling a rabbit out of the bag, it'd be like letting the Shelby County Community Services use the land, lease the land to Shelby County Community Services, because they're a nonprofit. Correct. Like I said, I'm pulling a rabbit out of a hat here. Kirk.
In regards to reading that statute, if we apply it the way that he's recommending to apply it, the legislative quote-unquote intent that you're implying, you said surplus property. Are you now taking the position that farm ground is surplus property?
Well, I believe in there, it also says that it's not profitable.
Right, but surplus was in there. This isn't surplus property. What the legislative intent was, as they're trying to claim, it's not surplus.
Surplus no longer needed, so.
We're selling a bunch of guns, it's surplus.
Yeah, this stuff isn't surplus.
I just feel like we all have opinions. Mine might be different than yours, so we need it in writing, is what I feel like.
But that's what we attempted, and why that last paragraph on that document that we got.
Right. And it's a prime example. Your opinion is different than his. So who's right? We got to have it in writing. What does the law say?
If the question were presented with all of the details to include defining public purpose and pointing to the case law on that, you would probably get an answer. But that was the biggest challenge, why you didn't get an answer before, a complete answer on the question of private farming, because the question wasn't properly presented, and they stated that in the opinion.
That's what leads me to fall back to the 1974 document. That's the only one I've seen that just
Nothing's changed.
hits the nail on the head.
That 1974 opinion from the Attorney General to, I think it was Logan County, actually went one step further than that and informed their then state's attorney that if the county proceeded, the state's attorney was obligated to prosecute the county board for doing so. I read that.
Go ahead, Mitchell. You got it.
I like Dave's idea. I don't know if there's any pitfalls to that, but I mean, that's the only close viable option seems to be that, I don't know if there's a pitfall as to that or something with the research, so you don't go up in weeds again.
If you want to know my opinion, that's the last thing I want to see happen again this year. It's not being farmed. Of course, I'm a farmer, and I think different than a lot of people, I guess, but it's not right to leave it idle. I don't know what you're going to do, or what you want to do, what's legal, or who's going to throw us in jail, or what. But I think it needs to be farmed. want some other opinions here. We've got a lot
Well,
of
the county
opinions.
government are not farmers. Sure, as a farmer yourself, and me and other members here, but I think some of that's the problem. You're acting more as in your private capacity as your individual occupation, and that's not your role in the county government. You gotta respond and react in a whole different manner. But it's not your farm or your farm, and it's not your skin in the game.
As much as I hate to say it, I think it needs sold. We have wasted so much time to make $30,000-$40,000 in the scope of the budget. That's nothing. Take the $2-3 million and run. Whatever it brings. I mean,
Got another opinion.
Mr. Chairman, Senator Ross, thank you. It would appear to me that, and I certainly don't want to cast any stones at people many decades ago, but when the state legislature abolished Poor Farm, had the county properly disposed of that ground then, we wouldn't have this 40-year-old pet questionable activity that we're concerned about to deal with today. So, I mean, if we want to look at intent, the legislature clearly told us to get rid of it, Mr. Orman, several years ago, and we didn't do that.
There was no, to my knowledge, there was no instruction on what to do with it. But when you take away the public use of it, then
It becomes surplus.
it's surplus property, just like the guns, just like the police car. It's to be sold
It should have been deemed as surplus property,
or sit and rust
and
and
then we
rot.
wouldn't be sitting here today, because we wouldn't have it to argue about.
I got a question. What about the cemetery? That's a county cemetery. The county ground is made to take care of the county cemetery, or should be. So there's your public purpose.
The cemetery is not 200 acres. The cemetery would have been full